As the deadly stabbing on Charlotte's light rail gains more national attention, several lawmakers are calling for the resignation of the magistrate who signed off on the suspect DeCarlos Brown's release from custody for his most recent arrest in January before the alleged attack. He was charged with misuse of 911, a misdemeanor, and was released from custody with an order to appear by a magistrate here in Charlotte. Chief Legal Analyst Khalif Rose joins us now to talk a little bit further about this. Khalif, you got some unique experience here. You're formerly the chief magistrate here in Charlotte. Can you explain the process of these judicial appointees, not judges, they're judicial appointees?
The process in North Carolina is pretty unique. There are some states that still utilize magistrates. I think ours is kind of closer to the justice of the peace, how we got to that process. But nonetheless, they're judicial officials appointed. And when they go through this process in terms of setting conditions for release, because that's what it's called, you make a determination of the person. And there's a number of factors, 15A 533, 15A 534. 15A 533 tells the magistrate, the judicial official, a judge or justice, whoever's hearing the case, what they should be looking for and how they can set the conditions: a written promise to appear, secured bond, unsecured bond, or release to some type of third party. And when they make that determination, you're looking at ties to the community, how long they've been here. It's in a nutshell, because there's about 11 factors. It's the likelihood of them committing a crime, specifically a new violent crime, and the likelihood that they'll appear. That's what you're trying to ascertain when you're making that determination. When we there's 30 plus magistrates in Mecklenburg County. When we train with those individuals, we would always walk them through the process. Now remember, they're individual judicial officials, so I, as the chief, couldn't tell them how to make a decision. Just like a district court judge couldn't tell them how to make a decision. They are the ones that are there, sitting there, listening to the case that's being presented to them by the officer that's bringing them in. They're the ones that's looking at the report that's in front of them that shows the individual's criminal history, and then they'll make a determination on their belief that, based on what I see, that they either will appear and they won't commit a crime.
Is it normal that a suspect that has a Class 1 misdemeanor charge against them gets released?
100%. I mean, happens on a routine basis. I'll give you guys a glimpse into how the magistrate system works in Mecklenburg County. There'll be magistrates upstairs that see the members of the public. There'll be magistrates downstairs in the jail portion that actually see members from law enforcement that come in and bring people that they've arrested. The first portion of the magistrate's determining, do they have probable cause to arrest this person? Once they make that determination, now they have to say, am I going to set conditions for release? Looking at that charge, misuse of the 911 system, that's a Class 1 misdemeanor. 120 days is the maximum sentence that you can go if convicted. This offense happened in January. So even if the magistrate that set the conditions, set no bond, which would have been unheard of, but if she set no bond, this individual would have got out in April, in May, and because at the time, if you've already exceeded the period where you can be in jail, you would have to release them, because now they can't do any more punishment. So to answer your question, yes, that is a typical bond, which they're released with a written promise to appear in those scenarios, and that facts for sure.
All right, we'll leave it there. Chief Legal Analyst Khalif Rhodes, thanks.
Queen City News Plus. Just search Queen City News on your smart TV's app store.